Oh, no.
Yes.
There was a and so he was talking and it was weird because he kept on talking about like the separation. And then he said, oh, well, you
Can't even get my words out. So, yeah. How are you? It's always fun to say,
so
Between the leasing company.
Discussion on move.
Yeah.
iron workers.
No, you're good. Okay.
Today is not 10. You're at 9:50.
I usually give it to like 10.
So, but that was, so we said like,
You need to get you guys an apple.
I think even the people who were professionals were like,
I got
it.
Okay.
Yeah.
Cool.
Sorry.
Well, it sounds like that's kind of been addressed in this, the exclusive remedy issue. You're okay. Overall thoughts. So, Andrew Brown with I'm sorry, I'm so bad. Yeah. Okay, Cummins Goodman. Yeah, George Goodman. Yeah. He does a lot of our but I use Andy as but Andy's very smart individual. All right.
Dinosaurs on your shirt?
It is, yep. My son is a huge fan, so when I saw it, I knew I had to buy it. Yeah, absolutely.
Yeah, get some dead face out of
That's
that one.
right.
Okay, I think we have everybody. So I'll go ahead and start with the affirmation that we have traditionally started with. Apologies, last time I chaired the meeting when we were out east. I forgot to do that, so I do apologize for that. So we would like to thank everyone for their time, effort, and participation in our work before us today. We want to recognize that it is very difficult and important work, and we appreciate and value the perspectives and professionalism that everyone brings here today. Thank you. And we will go ahead and start with roll call. I had to wait until Terry stood up.
All right. Sarah Merrick. Here. Scott Strickland.
Here.
Co-chair Strickland. Margaret.
Here.
Lauren.
Here.
Sarah Duckwall. Ryan.
Here.
Stacy.
Present.
Oh, Co-chair Priest.
Here, present.
Kim. Here. Yay. And Director Stolfi, I believe, is online.
Yep, I'm here.
Andrew or Director Stolfi had a couple of things that he wanted to share. Did you want to go now, Director?
Whenever the co-chairs would like.
We would love to have your input now, sir.
All right, great. I'll be quick. I just wanted to give an update on the WC administrator search and then share some news from the GRB yesterday, which you might be aware of anyway. So we're, as I mentioned, really thankful for all the input that Sean and I got during our listening tour following Sally's retirement. That's concluded, and we've prepared everything, and we'll be formally launching the recruitment for the next WCD administrator next week. We waited until next week because we always do a 30-day or so public announcement. I didn't want that to end right before the holidays. So that'll end, around the 10th or so of January. We're already scheduling all the rounds of interviews, have reached out to the co-chairs to make sure that MLAC has a role and a say in that interview process. So would expect if things go well to have that wrapped up by sometime in February, and to have a decision, have an administrator in place. And again, really thankful and looking forward to MLAC's involvement in that process. And some others who are on this call right now have also received invitations to be part of our stakeholder panels as well. So thank you all for that. And then the second thing, just want to mention, due to MLAC's kind of involvement in the WBF, is the governor released her recommended budget earlier this week. Part of that recommended budget, which of course has to go through a whole legislative process, includes a pretty substantial increase to BOLI's funding, secured in part just for the next biennium by a one-time contribution from the WBF. So a sweep in legislative parlance. That is something we were aware of as a possibility. In no way, endangers or affects the WBF. So it's not going to impact and wouldn't impact the services that and things that the WBF supports. As I said, of course, it has to go through the whole legislative process. So I'd expect robust discussion upon that next year, and would welcome any questions or anything that MLAC would like on that. But those are the two things. Thanks.
Thank you. I see Sarah Duckwell has a question.
Thank you, Director Stolpe. A question on that: how is that going to affect, or will it at some point affect rates for the Workers' Benefit Fund?
That's something we would have to work through next year. So it's a $15 million revenue transfer, but the WBF has a very robust fund balance. We would, during next year's rate making, if this is approved by the legislature, it would get taken into account during the rate making, but it'd be, I couldn't really say at this time if it would even have any effect. It might not.
Great. Any other questions? Not seeing any. Thank you for the updates. I see next on our agenda is a public comment period. So wanted to hold that open to see if there were any public comments. Not seeing any hands online or any people jumping up here. All right, next on the agenda, we have a review of minutes from the November 7th meeting.
I move approval.
We have a motion to approve from Sarah Duckwall.
Second.
A second from Sarah Merrick. Any discussion? All those in favor signify by saying aye. Aye. Any opposed? Any abstaining? Okay, and department updates.
We have Sarah Larson from the board online.
Hi, yes, I'm here. Thanks for having me today. The board doesn't have any updates at this time.
Okay, thank you.
And the division does not have any updates at this time.
Okay, we're flying through here. So next up, I see LC presentations, starting with Matt West.
Good morning, co-chairs, members of the committee. I'm Matt West. I'm the interim administrator of the Workers' Compensation Division. I'm here to talk about two different concepts that the division is putting forward in the upcoming session. The first one I'm here to introduce and ask for MLAC support is we'll start with LC 394, which corrects an oversight in ORS 656230 related to lump sum payments of permanent partial disability. So when a worker is awarded permanent partial disability or PPD, they can request a lump sum instead of being paid in monthly installments. A little history on how we got here first. So prior to 2007, if a worker wanted a lump sum, they would fill out a form and they would come to the Workers' Compensation Division. We would review the form and the criteria, and then we would inform the insurer whether or not to approve or deny the lump sum based on the criteria. In 2007, WCD ran a bill to add this to statute, reasons to approve or deny a lump sum, kind of take the middleman out of the process and just have the worker apply directly with the insurer. Statute outlines reasons to approve, reasons to deny, and then the insurer would do that based on the statute. Our intention with those changes in 2007 was to take us out of the process, and also the intention was that if a worker waived their right to appeal the adequacy of their PPD award, then they would be eligible to receive a lump sum payment of that award. However, currently the worker may have to wait up to 60 days for that appeal period to expire before they can successfully request a lump sum payment, even if they waive their right to appeal the adequacy of the award. This came to light in a 2023 Court of Appeals decision, Giltner v. Safe. The court concluded that even if a worker waived their right to appeal the award, the law still didn't require a lump sum payment if the award was not final by operational law. So basically saying it still needed to wait that 60-day period. So our goal with this legislative concept is to ensure that a worker who waives their appeal rights can get the full amount of their award quickly. So this concept would require that a lump sum payment upon the worker's request if the worker waives their right to request reconsideration of the notice of closure. So insurer issues the notice of closure, PPD award, worker waives their right. Reconsideration is a process, the appeal process of a notice of closure. So if they waive their right to request reconsideration, then they would be eligible to receive their award in a lump sum. The change also, the concept also would allow the insurer to deny a lump sum payment if the insurer has requested reconsideration of the notice of closure. So as long as neither party appeals, then the worker would be eligible to receive their award in the lump sum. This allowance of denial if the insurer requests reconsideration on the closure is in addition to the current existing reasons to deny a lump sum, which include when the compensation is stayed due to a hearing request, and if the worker is actively enrolled in vocational training. So we've since we've been working on this for a while. We've held a number of meetings and then more meetings. We received feedback from stakeholders on the concept and plan to bring an amendment to make some changes. So I think you should have a copy of the concept, the statutory language that came from Legislative Council. And then there should be a version that has some highlighted areas on it. So that shows the changes that we're proposing to make in response to the conversations we've had with a number of stakeholders. So
Matt, we
yes.
have it stapled together. We have the new one with the old one stapled together.
Oh, perfect. Should be in your packet. Yeah.
This is not an electronic version.
I'm sorry.
This is not an electronic version.
No, because we were still working on it
Yeah,
at
no,
7
I
o'clock
just-
this morning.
No, that's fine. I really understood. I can think of.
So in response to feedback from stakeholders, some of the amended changes that are highlighted on that draft, some of those changes that have been requested, kind of a reorganization of the statute by moving section 3, rewording it, and moving that up to section 1, kind of makes it read easier. And then we also, in conversations, there was the request to increase the threshold for automatic lump sum payments. So current law requires a lump sum payment for awards that are $6,000 or less. So the worker doesn't have to apply for a lump sum. They just get that automatically. This threshold has not changed since 1995. So it applies to fewer workers today than it did 29 years ago. We've received general support for increasing the $6,000 threshold, but haven't landed on what that new amount should be. We're still currently discussing the specific amount with interested stakeholders and plan to share what the proposed amount would be with MLAC once we have consensus on an agreed upon number. So that's the general overview of the concept and what we're trying to accomplish. And I'm happy to answer any questions that the committee has.
I don't know if you think you Chair and Director. I don't know if you could tell us more about the 2023 case that resulted in the no sum being issued, the lump sum. I guess I'm having a hard time understanding because of it wasn't final by law. The insurer felt that they didn't have to issue the lump sum. Is that correct?
Yes, and so the case was appealed and went through the courts, and the court it's essentially concluded that if the award isn't final, the insurer is not obligated to pay in a lump sum.
Okay.
My understanding of the case, and I don't have
Yeah, you're
specifics,
good.
is there's a scenario where the worker could request the lump sum and then still appeal the notice, other aspects of the notice of closure.
Okay.
That appeal could result in the notice of closure being rescinded, which could affect the award. So I believe the court felt or concluded that if the award's not final, if those appeal rights haven't been exhausted, then it still could change. And so that's why we're adding the workers' waives, being a little more specific that they're waiving the right to request reconsideration of the notice of closure, so we don't end up with that scenario.
Any idea how often we've seen a lump sum be withheld due to that process?
I don't have
Any data? Yeah,
nothing.
nothing. Okay. Just curious. Thank you. I appreciate it.
And Sarah?
So what happens if, by some law that they can still appeal, and what happens to that money?
I'm sorry.
Can that money come back if, it's overturned or changed or?
If the award has already been paid out.
Yeah.
So in the case of the lump sum, if the worker requests a lump sum and they waive their rights under this new law.
So you're saying the new one fixes that caveat?
The new one would prevent that when the initial notice of closure is issued. If the worker requested lump sum and then later submitted a request for reconsideration, those come to the department. We would deny the request for reconsideration based on the fact that they waived their right to appeal the notice of closure.
Okay, so
There's a form that the worker fills out, so there would be, and they sign saying, I'm waiving my right to request reconsideration. So we would then deny the request for reconsideration based on the fact that they filled out that form. And does that answer your question?
Other questions, Lauren?
What's the rough number of PPD cases that would fall under the current $6,000 threshold?
It's a great question. So that would fall under the 6,000?
The current, yeah.
Yeah. So in 2023, just want to make sure I'm reading this right. So 2023, there were 2,850 PPD claims. 1,500 had awards over $6,000. So the percent with awards over 6,000 was 53%. So 47% would be under 6,000.
For those over the for those over 6,000, do you have an average of what that number looks like, or has that been in consideration for what the new threshold would be?
That's what we're currently discussing, but I have some data. So it's like 75% of PPD awards average 13.7 thousand. 36,000 is about 90% of awards.
Would you be able to make that chart that you're reading off of available to MLAC members?
I believe so, yeah. That's
Any other questions? Any of our online folks?
I have one. Curious if there are any concerns about opportunity costs with regards to lost investment income or anything like that, that the department would have to recoup with the payments going out quicker.
sorry, can you repeat the question?
Could you repeat the question one time? There was-
Sure. Let me try hold this. This is better. Wondering if there are any opportunity cost considerations that need to be taken into account with lost investment income or anything like that, that the department currently relies on that would change budgeting for the department with the payments going out sooner.
Yeah, so the PPD awards are paid by the insurance carrier, so it's not money that the department has eyes on. And so from our standpoint, we don't, that's not our money. So we're not like holding on to it, collecting interest or anything. It's the insurer's the one that pays out on the claim.
Okay, perfect. Thanks for clarification.
I guess, thank you, Chairman. Can we get more information on the 2023 case? I'd just like to know the
Sure,
situation and the
we can provide
circumstances
you,
around
yes.
it. I'm really curious. I have a hard time seeing a case where, you know, the PPD's been requested in lump sum, but yet it's not finalized. I'd just like to see the nuances of that.
Yeah, we can share the.
That'd be great.
Certainly share the.
Thank you.
Yeah.
Thank you.
Any other questions from folks on this one?
I'm sorry,
Yeah,
not
go
really
ahead,
from that, but just insurer perspective, you know, what's your take, or if anyone would like to address that, you know, their view on lump sum payouts?
Sir,
and
could you repeat that again, Mary?
insurer perspective on their view of lump sum payouts, and, you know, if this is an amenable change?
Yeah, they're wanting to hear from me, or I mean, there are some in the
No,
room
just
that.
at some point, you know.
Sure.
I'd love to hear a stakeholder viewpoint on that. I don't know if now's the time for that, or.
People weren't listed, see if people signed up.
Sure.
I can share just sort of high level. We've had conversations with insurers and workers representatives and have had general support for the concept. They can provide more specifics on it.
I don't
want to speak for them.
I don't want you to speak for them.
No,
either.
they all said they love it and that you should just pass it. No question asked.
At some point, I would love to hear that perspective.
I see we have a friend from SAFE here willing to dive in on this one.
Yeah, thank you, Mr. Co-Chair. Members, for the record, Evo Trummer, Government Relations Director for SAFE. Generally speaking, we've been working with the department and other stakeholders on the concept of the bill, and for the most part, we're in full alignment on this. There are a couple of details we're still working out, but generally speaking, I think this is a good step.
Thank you.
Thank you, bud. All right, any other questions on this one? Not seeing any. You have another.
I do have another. Are we ready to move on to the other? Okay. This is a little bit more technical. So I'm just gonna start with
Can I
that.
just say, I did not print out all the pages. There are a few copies of the full document in the back. I think there's 10, but I only printed the changes that we are proposing. Okay, so there's just 6 pages, and I did the same thing, printed the new one on top of the old one.
Okay.
So it's
Thank you, Terry.
LC 390. All right, go ahead.
Okay. And LC 390 is I believe the entire concept is 42 pages.
It's 48.
48 pages, sorry. I didn't want to cut anybody short. We can talk about why, but the majority, the bulk of the changes are in the first pages that she printed. The rest are changing a term in related statutes. I can go over that. So Do I need to say who I am again? Are we good?
I think we're good.
Okay, thank you. Okay, so I'm here now to present and ask for MLAC support of LC 390, which updates the current worker leasing statute. So one of the things the division is responsible for is licensing and regulating worker leasing companies under ORS 656850. For those who may not be familiar with worker leasing companies, they provide services like payroll, human resources, workers' compensation coverage, and others to client employers and their workers. A lot has changed since this statute was first enacted in 1993, as you can imagine. Because of those changes, there's been a lot of discussion at the legislature, and during the interim legislative days in 2023, the legislature recommended that the division update the worker leasing statute. So the definitions and terminology currently in the statute don't necessarily reflect current industry practice, and some of the reporting requirements don't take advantage of modern technology. So our goal with this legislative concept is to bring the statute up to date while keeping its strong protections for workers and employers in place. So current law defines a worker leasing company as a person who provides workers to a client. However, this definition doesn't necessarily reflect business practices of modern professional employer organizations, or PEOs. The outdated definition is a problem because it increases the risk of disputes over the scope of a PEO's coverage and licensing obligations. The division and its PEO stakeholders generally agree that PEOs qualify as worker leasing companies, despite the change in industry practice. However, if legal challenge were presented, it could expose PEOs and clients to significant liability, because current law does not allow an employer to transfer its workers' compensation coverage obligations to a third party outside the context of a worker leasing arrangement. There also isn't currently a definition of a professional employer organization. The worker leasing company is the term in statute. So the proposal addresses this problem by deleting the term worker leasing company from the statute and replacing it with the term professional employer organization, defined as a person that assumes specified employment responsibilities for client workers under a contract. This definition is consistent with the model language used in many other states, and we believe the vast majority of current licensees fall under this definition. It would also, the concept would also adopt the term co-employment as a shorthand for a PEO's relationship with client workers. This new language is based on model language from the National Association of Insurance Commissioners, or NAIC, which is used in many other states as well. Current law requires a worker leasing company to provide notice to the division whenever it provides coverage to a client. Companies meet these requirements by using forms called worker leasing notices and termination notices, which they fill out, send to the division, and then are manually entered into our employer data system by division staff. Worker leasing clients are the only carrier-insured employers whose coverage data is reported using a form-based process. Coverage for most other Oregon employers is reported electronically by their insurers to the division using what's called electronic data interchange, or EDI. So this problem arose over time. When 656850 was first enacted in 1993, EDI reporting wasn't available. So worker leasing company reporting requirements were not written with this type of reporting in mind. The proposal addresses this problem by requiring a worker leasing company to provide notice to its insurer rather than division when it provides coverage to a client. The division would then accept client data from insurers via EDI, which would greatly reduce the administrative burden on worker leasing companies and the division. In the concept, coverage termination notices would continue to be reported to both the division and the insurer. The concept would also allow the division to adopt rules on how insurers write policies to cover PEO clients. And we plan to explore the possibility of requiring insurers to provide coverage under multiple coordinated policy, or an MCP model, in which each client would be issued its own policy number. Using this model would make it easier for the division to track and share coverage data with clients. That would require rulemaking, which we would certainly do if the concept passes. The concept also would allow the division to share certain coverage data information with insurers, so that if a PEO client gets new coverage without informing their insurer or the PEO, there wouldn't be any confusion on who's responsible for an incoming claim. So we get new coverage, but it's not coming from the original insurer. We haven't received that termination, and we would let the other insurer know that a client has secured new coverage. So apart from these changes, PEOs would be subject to the same requirements that apply to worker leasing companies under existing law. This will ensure that there continue to be clear roles of responsibility for coverage and claims processing, and the client employer continue to benefit from exclusive remedy protections. We appreciate the engagement and feedback we've gotten from stakeholders on this legislative concept. And like the other one I just shared, we'll be bringing an amendment to reflect the input that we've received. And that language is highlighted in yellow, like the other one. And that you'd see what our concept is, and the yellow would be the changes that we're requesting based on those meetings we've been having with interested parties. And our plan is to submit the proposed language changes to Legislative Council in the coming weeks to finalize that. One important change in the new section is a new section providing that nothing in ORS 656-850 creates an employment relationship for the purpose of any other law. This was in response to stakeholder concerns that our use of the word co-employment to describe the PEO-client relationship could lead into other areas of the law. Making these changes would decrease the likelihood of coverage and licensing disputes, and would also significantly reduce administrative burdens on worker leasing companies and the division. I'm happy to answer any questions that the committee has on this concept.
I see Sarah, and then Margaret, and then maybe Ryan.
Thank you, co-chair and directors, interim director. I have just a logistical question on now PEO. I read that it requires coverage of all of the client's employees, even ones that they're not, and unless I'm just misinterpreting that, and they're not ones not that they didn't provide.
Yeah. So currently, worker leasing companies, and would stay the same, that if a worker leasing company or PEO, we'll use the term interchangeably. If they provide coverage to a client, then they're obligated to provide coverage for all of those clients' workers. So they can't just say, we're going to cover these ones, but not these ones, unless the client employer secures their own policy to cover all of their workers. So it's an all or none. If the PEO is providing coverage, they're providing coverage for all of that client's workers.
So it's an all or none scenario, and that's a relationship between the client and the PEO.
Correct.
Who does that?
No, the client has the option to secure their own coverage for their workforce, for their employees.
But they'd have to do all of them, including the PEO employees?
No, they would just do all of their
own.
Yeah. This concept, I see where you're
weird
headed.
To me.
Yeah, the concept that PEOs are actually saying, hey, here are a number of workers that we're going to provide to you, is kind of that's the outdated piece that we're trying to resolve. And there are no
one cares about this weird coverage.
I'm sorry.
No one currently cares about this weird coverage issue of who provides the coverage. That seems to be working.
It seems to be working because it's very clear that if the worker leasing company or PEO is providing coverage for this client, they're covering everybody, unless the client gets their own policy. So it's all or none. And the PEO is also covering their own employees as well.
Right.
And multiple client employers.
Maybe later on we could go through some examples of
Sure.
the questions.
Yeah, and like I said, there are people in the room that know a lot more about it than I do that could also probably help add some detail that I'm not adding.
Thank you.
So, Margaret, you go ahead.
When this was brought up last year, I remember a witness, and I'm sorry I don't remember his name, but I remember that he testified by Zoom, and he was out of state, and he raised concerns about the exclusive remedy. And I'm wondering if you can point out the section. I'm assuming that since you specifically said something about protecting and maintaining the exclusive remedy, that was addressed. And I was wondering if you could remind me what section that was in.
Certainly. And I just want to call out, and I believe that was the February short session it was not our bill. It was a bill by a legislature who was trying to make some changes, very different wording. So our bill is very different than that one. Just wanted to clarify
So
that.
this is not a tweak on that bill.
No,
it's
that
kind
was
of
a
to move-
separate,
okay,
yeah, it was
okay.
a separate
That
concept,
makes- okay,
yeah.
that makes sense.
And there is so currently in statute, and I might have to phone a friend, or we have our policy analyst, and the exclusive remedy statute says that worker leasing companies and clients are covered under exclusive remedy. And so we are eliminating worker leasing companies and adding professional employer organizations, so there wouldn't be any change to the current status quo.
Thank you.
And we can follow up on, I don't know if Aaron knows off the top of his head which page that's on. I believe it's in one of the later pages of the 48, because it's just switching out the terminology, deleting worker leasing, adding professional employer organization.
I appreciate that. Right now, all the.
Yes, page 42, paragraph, no.
Thank you, Chair, Co-Chair. Committee member Margaret kind of already addressed my question. It was more about, what was this 2023 bill that was a version of the bill that was proposed? Who were the stakeholders that, had some concerns that resulted in the department or the division tabling the bill for now?
Yeah, so there were two, so there's PEOs and worker leasing has been a hot topic. We'll just put it that way. So for the so there's two things, and I'll clarify. I apologize if I confuse things at all. So in 2023, we put the long 2023 session, we put forth a similar bill and as we were having discussions, there was some concerns from the carrier side about termination notices no longer coming to the director. We didn't have enough time to work through that, and we didn't want to work it out in public. So we pulled that bill in 2023, and so we said we'll come back in 2025. We don't typically put policy bills forward in a short session, which is why we didn't do it in 2024. And so we've had those discussions, and that's why I mentioned that termination notices would continue to come to the director. After feedback, that was an important thing. So we said, hey, we're not going to, we can keep that part in because that's the current process. During that same 2023 session, after we pulled our bill, there was a lot of another department within the state government was having their own discussions related to PEOs. And outside of that, then in the short session came that bill that you're referring to, where we were down in the basement and there was a lot of people and a lot of discussion. And I believe it was, I know NAPIO was one of the interested parties that had concerns with that version of the bill. We have worked closely with NAPIO, among others, on this bill, and they're here. I don't want to speak for them, but I believe they support, unless something changed in the last 24 hours. And so, I'm sure they would be, if they still have concerns, would be more than willing to share what those concerns might be.
And I do see that we have testimony signed up from two folks who I believe identify.
Perfect. Yeah.
Them, so we'll get to that.
Yeah, appreciate it.
Any other questions? Online questions? Not seeing any. Not hearing any. Okay. Thank you. I see we have two folks signed up for testimony. Looks like Jenny and Ann.
Should I go or stay?
Maybe go, but they
Stay
may pull you
close.
back in.
Not far.
Wherever you want to sit.
Okay, sorry. Yeah. Thank you, everyone. It's
Good
really
morning.
nice to be here. Thanks for letting me participate. Co-chairperson Strickland and Priest. My name's Ann Donovan, and I'm the president of Xenium, a local PEO, and the leadership council chair of the Oregon Working Group for the National Association of Professional Employer Organizations, also known as NAPIO. I'm here today on behalf of NAPIO to ask the Management Labor Advisory Committee to support LC 390. NAPIO is the largest trade association for PEOs, which provide comprehensive human resource solutions to small and mid-sized businesses. The average PEO client has between 10 to 15 worksite employees. Payroll, benefits, HR, workers' compensation, employment tax remittance, and regulatory compliance assistance are some of the many services PEOs provide to growing businesses across the country. In Oregon, our industry serves more than 3,000 Oregon small businesses employing over 31,000 employees. Although commonly referred to as PEOs or professional employer organizations, industry participants in Oregon have long been termed worker leasing companies and are subject to licensure pursuant to ORS 656850. With regard to LC 390, we've been in close communication with the Workers' Compensation Division during the drafting process and feel comfortable with the language in the LC draft before you today. We appreciate the department working with NAPIO to address some of the definition and amendment suggestions provided by our membership. LC 390 will modernize the Oregon Revised Statute to reflect industry practices in the 21st century. It does not change the responsibilities of the PEO or client in providing workers' compensation coverage. The language in LC 390 is based on NAPIO's Model Act and updates outdated statutory language that was called into question by the legislature during an informational hearing in 2023. On behalf of NAPIO, we respectfully ask for your support of LC 390 today. Thank you.
Thank you.
Thank you. Chair Strickland and members of the committee, my name is Jenny Dressler, and I am the lobbyist for NAPIO. I want to speak to a little bit of the question that Ryan raised, specific to some of the politics, and several of you saw us come in February of 2024 to this committee. In 2023, we came forward after working with the Paid Leave Oregon program with Oregon Employment Department on a solution to a problem that we had run into in terms of reporting, reporting within the Francis online system and being able to access certain provisions for Paid Leave Oregon that other small businesses and other small business clients have access to. So we worked on a solution specific to that program. There was nothing related to this statute at that time. But the bill didn't, although the bill advanced, it was Senate Bill 881 at the time, the bill advanced into the Senate unanimously. When we got to the House, people started having questions, legislators started having questions about some of the statutory authorization and how PEOs interface with different programs. And so in 2023, later that year, we came back to the committee, at that point it was the House Committee on Business and Labor, for an informational hearing on the issue that we had raised earlier that year. And it was at that time that the committee realized that the worker leasing company definition that was in current statute maybe was outdated and was not a good fit for the industry as it is today. And so there was quite a bit of discussion at that point and a desire to move forward with a solution. The bill, House Bill 4005, that came forward in the 2024 session was not drafted with NAPIO. And it was one that essentially would have unraveled our business model in Oregon and prevented us from providing co-employment services to our clients. And so that bill did not move forward. And so I think that at least from our perspective, the first step in addressing all of these issues is to address the definitional issue, update that, modernize it, so that our industry can then move forward with conversations with the Employment Department and others about how we interface with other worker benefit statutes. So happy to answer any questions. The politics were a little convoluted.
Questions? I guess I have one, and this may be better suited to Matt West. So in terms of stakeholder engagement, this is a WCD bill that has had NAPIO's input, and are there other stakeholders that have been included? Or do we have kind of like a high level of the input that's been received thus far?
Yes, so the highlighted portion on the, well,
First 3 pages or so?
yeah, are
Yeah.
based on input. We've had discussions with NAPIO, Safe Corporation. We've had discussions with them, the property casualty, OTLA. So yes, we've had a number of discussions and have attempted to incorporate the feedback that we've received.
Okay. Yeah, I would say the use of the term co-employment and co-employee, I would think is confusing to folks when it's intended only for this one specific purpose. So I don't know if there is another term that could be used, like covered worker or some other way of referring to folks. I know a lot of times representing workers, especially in a construction environment, they look to the union to represent them for sort of a variety of issues. And so if you have folks that have a range of sophistication legally and knowledge of workers' comp generally, it can be very confusing, I think, when they're saying, oh, well, you're a co-employee or this is your co-employer, but not for purposes of, bargaining, for purposes of any of these other sort of reasons. So I don't know if there's another term that could be utilized or is utilized elsewhere, or if that's an unreasonable concern of mine. But that was just kind of the first thing that was flagged when I was reading this was, and the sort of discussion of co-employment, co-employee, direct hire employee, and all of that. And then later on, it's saying, actually, there is no co-employment relationship for any other law or any purposes of any other law. I don't know if that's a thought that's been addressed.
So I think you've asked two questions. I'm going to have Anna address the co-employment because I think
Sure.
it is a different, we have to talk about joint employment, right? And especially in the contracting space, you're probably very familiar, and the legislature was as well, very familiar with joint employment. This is a co-employment relationship, and I'll let Ann describe the differences. On the language that you indicate, that we are still working through that language, and I will say I'm not sure that we understand how that will interface with as co-employers, we're able to provide health coverage, we're able to provide 401ks, right? We're able to provide retirement plans as co-employers, and so I think we are still trying to figure out that language. Specifically was not one of our comments, so we're trying to figure out how that would interface with the existing responsibilities that we provide.
And I understand that the business model is a more holistic approach than just work comp, but that's just something that I thought.
Absolutely. I'll let Ann address the co-employment question because that's a good one.
Yes, thank you for the question. Co-employment is uniquely different than joint employment, as Jenny said. Our co-employment relationship with our client companies is certain specific employer responsibilities that are outlined in the contract. Co-employment is part of the industry norm and how we deliver our services to all of our client worksite employees. It's in all 50 states and part of the NAPIO Model Act. So the term co-employment is longstanding and one that's important for us to be able to deliver all of the services that we bring to bear to the small business population. There might be an attorney, one of my colleague peers on the phone that can address that question more deeply from a legal standpoint. So I'd invite anybody to jump in, but that's the premise of this is that it and I believe that, I don't want to speak for Work Comp Division, but their note to say that this doesn't impact other agencies is because they didn't want to overstep I'm assuming, and just really reference how that affects the Work Comp Division.
Right, our obligation, we license worker leasing companies or PEOs, and really we're trying to stay out of the conversations going on at in other agencies and other areas of law to try to keep our scope narrow to what we do. Again, it's something that if there are concerns with that particular language, happy to listen to feedback and tweak as needed.
Is it relevant? I mean, if it's just workers' comp and they're already covered under workers' comp by the PEO, I mean, do we need to call out co-employment for workers' comp?
Yeah, I guess that's kind of to some extent, my question is there a reason it has to be called co-employment? Is there a better term that doesn't seem as loaded to me?
May I?
Sure.
So
Anyone, go ahead.
Okay. From the industry standpoint, we believe it's very important to call out the co-employment. It is the cornerstone for how we deliver our services to our clients and their employees. So while this is one aspect of what we do, and we, again, as I said, we very much support and agree with this language, co-employment is a term that is, my company's been operating under for over 30 years, as has all of our peers in the industry in all 50 states. So it is an important term for our industry, and we would see that as a really important term to lead in.
Okay. Other,
And I'll just
Yeah, go
add,
ahead.
our goal with this is also to be as clear as possible. So if we're using the word co-employment and client and co-employed, we want to define it so that there isn't any confusion. That's why we added the definitions.
Yeah, and I would say at the very least, including there's a section number, and I assume it's a placeholder on what I have as number page 3 that's
Yes.
highlighted. Including that perhaps in the definition, I think would maybe make it a little clearer, at least if that term is necessary, as a possibility, but happy to dive more into this as time progresses. Any other question? I see Lauren.
I just have a really basic question. Excuse my ignorance on PEOs. What are the business types or industries that you most serve?
Great question. Yes, really, we're kind of agnostic when it comes to the types of industries we serve. I can talk about my business. We serve professional services, light industrial, manufacturing, healthcare. We have law firms. We have really everything under the sun. There's no limit to who we serve. Each PEO might choose industry niches that they want to focus on. In my case, for the last 30 years, we've worked with all industries. The key that's most important in the PEO industry historically is that it's small business. So I referenced that our average size is between 10 and 15 employees. So what we're bringing to bear in our business model is professional human resource services and products that can help support the small business industry. That's who we serve, and they're part of our mission.
If I can add, so in your packet, MLAC has the different questions, right? And so we've
I saw
answered.
the checklist too.
Yeah, and so for LC, which one is it?
390.
The question, there is some data in there that just shows the number. Over the past year, our worker leasing our worker leasing licensing program received and processed approximately 5,000 notices for worker leasing clients. And so our records reflect that approximately 8,000 employers obtained their workers' compensation coverage through the worker leasing company. So it's a large amount of employers that are covered in this way.
Thank you, and I appreciate the list. I know I always hammered on that back in the day, and it's nice to see actual sort of a breakdown that helps with our analysis very much. So we appreciate that.
Yeah, we figured we help support getting that out there. We should probably answer the questions, follow what the committee wants. Yeah.
Other questions from folks? I guess I have one too with the co-employment status. Does that in any way expand the exclusive remedy? So say if I'm, again, in a construction setting, if I'm a worker for employer A who uses the same PEO as employer B. I know traditionally if employer B's negligence injures me, I have whatever work comp claims against my employer in A, but may also have negligence claims against employer B on the same site. If both of those employers use a PEO, the same PEO, does the co-employment status somehow expand the exclusive remedy so my negligence claim would go away? Is that known?
So in that scenario, there are two client employers, one PEO. I believe it might be something that the contract between the PEO and one client is independent of the contract between the PEO and the other client. So that worker is wouldn't be co-employed by both client employers, it'd be co-employed by their client employer and the PEO.
Right, but since they have the co-employment as defined relationship with the PEO, does that expand the coverage to
No.
other employers in that sense? No?
No.
Okay.
We don't believe so.
You're thinking too much, Scott.
You know, it's my third cup of coffee. I'm starting to get it out there on the fringe, so. Wait till I get my muffin. Other questions from anyone? Not seeing any hands online or anybody jumping up in the audience here, so. All right, well, thank you very much for the presentation. Thank you for staying and testifying and answering some questions. All right, so I see next on the list, so we'll go through the LC presentations, and I think we'll do a quick caucus to provide time for the injured worker panel to kind of come up and get set up, make sure we have everybody online that we need. So next up for LC presentation, I see AFSME, and it looks like Odalise.
Good morning. My name is Odalis Aguilar Aguilar. I use she, her, ella pronouns. I'm a global coordinator with Oregon AFSCME. My presentation will be short and brief. I don't have an updated LC to give to you right now, but it is LC 3235. The first draft that we got was a little scary, and I didn't, I didn't want to give you something first and then make you look at something else. So we're waiting for the draft still to be updated. I think the deadline is coming up here pretty soon. So if I didn't hear back, repeat that number again, the drafter. But it is related to ORS 656.
Can you repeat the number for the LC?
Yes, LC 3235.
Perfect, thank you.
Yeah. And then the ORS seeking to change and amend is ORS 656-210 related to short-term disability. I think most of you maybe are familiar with AFSCME, but we are a labor union that represents about 38,000 workers across the state, both in public and private sectors. Our membership kind of ranges from folks working at OHSUs, we represent almost everyone on the Hill except for the nurses, to folks in correction facilities, to behavioral health facilities across the state, the state hospital, SACU, and a bunch of county and local government workers. And our mission is to ensure that workers have equal access to compensation for labor and to lead in economic and social justice for all workers across the state and their families. And so the LC that will be coming forward will seek to address a wage disparity problem that we see. So the workers' compensation is supposed to match when you're out on workers' comp what you would receive if you were working. But when folks are out, at least the way that we've understand it, and the way that we've talked to other stakeholders is that the take-home pay is not equal to the pay that folks get when they're out on workers' comp, especially if they are lower income workers or lower income earners, because the formula used is kind of straight across the board and doesn't look at how much you're actually making pre-injury. And so the one pager that I shared with you kind of goes over a little more about the problem, but it's just multiplying by 66 2/3 for the time loss rate. And the worker ends up getting paid out whatever is less. So for a family or for someone working and making maybe $50,000, $60,000 a year, they're not getting taxed at the same rate as someone who's working and making about $100,000 to $125,000 a year, or even like 80. And so there's a disincentive to apply even for workers' comp for low income earners, because they know that they're not going to make back the even close to what they would actually be making if they were out. So some folks just straight up are not applying because they know that they're not going to get even close. to what they would make. And so the solution proposed is giving workers a benefit to get that kind of equal compensation out when they are out on an acceptable or an accepted compensable claim, so that they can focus on getting better and going to their appointments and fully healing to get back to work and not having to worry about getting injured again so quickly back on the job or rushing to be better. And so when I replied to the drafter, I made sure that there's a cap, there's a floor. We want to keep that cap and floor. So our intent is not to mess with anything like that, but really just to bring like lower income earners up so that they're able to focus on getting better. And I plan to come forward again in January when I get to answer more of your questions. But I really wanted to share this and give you a heads up that this is something that AFSCME is really interested in looking at. I know that there have been conversations in the past, in the last couple of years. Joe Baser, maybe who you all remember coming in front of you in previous years, I think had conversations with other folks. And this is a project that he's passed on to me to continue working on. So when I do have a better looking LC draft, I will share that with you and come back in January and answer any other questions that you may have, but I'm happy to take just initial thoughts, feedback, or anything like that.
Thank you. Any, Sarah?
Where do you think you're going to land
On
the LC percentage wise?
we are looking to do full wage replacement for at least low income earners, and then that definition is still like in the works. It's my understanding that workers' comp, when someone files, you file based on your own wages, not like your family income. So it's been a little tricky to kind of like sparse out and land on a number.
So just the floor then?
Sorry?
Are you looking at just a floor then? I mean, I'm just trying to understand what we're going to expect. And
The LC draft that you would get back would probably say keep the floor and the cap that already exists in workers' comp. And then the only number really that we would be changing is, instead of saying 66 and 2/3, it would say full wage replacement for a worker.
Okay, so take out the percentage altogether
And
full wage replacement within a cap and floor.
Yes.
All right, thank you, Co-Chair. Currently, average weekly wage is calculated based off of gross earnings. When you're saying full wage replacement, are we talking gross? Or are we talking net? What kind of wage?
Gross. So after everything is taken out, and then after any of the other deductions that are
So you
happening.
would include taxes?
Yeah, it would
that
include
full
taxes.
replacement?
Yeah.
Okay.
Yeah.
Essentially, that's what the 66.6% is doing currently, right? Is we're looking at gross earnings before tax deductions. The 66% takes into consideration those taxes.
Right.
So,
But when you have a low income earner that makes $35,000 a year, that 33% that they're taking is not actually close even to what they would really get taxed, and so they're missing out on a lot of money.
sure. So we're looking at bringing them full as far as after taxes
Yes.
and all that, their health insurance,
Yeah.
all those deductions.
Mhm.
Okay.
So a net,
Yes.
So
a
a net,
full
not a
net
gross.
A full
replacement.
net replacement.
Okay.
Yeah.
Yeah, and you're right, Ron. I think the 66 and 2/3, the intent is to sort of offset for all of those deductions. But I know,
Yeah.
in making what I do now, I am not at a marginal rate of a third. And
that's-
certainly, yeah. When I know when I went through the process for my injury, I don't want to say I lucked out, because obviously still have significant pain and problems from that injury to this day, and it limits my ability to do things. But I lucked out in the sense that I had a lot of overtime, a kind of unusual amount of overtime in the year leading up to the injury. So it ended up offsetting that my wage replacement was almost accurate for what my typical expected wage would be.
Yeah.
But
Go ahead.
it would have been about a 20% reduction had I not had the benefit of that huge amount of overtime.
Yeah.
Which that huge amount of overtime was part of what led to the injury. So also, again, not a great
Sure.
benefit. Yeah.
Yeah.
So,
And I think in my experience, I've seen it kind of go both ways. And I think that was the understanding of average weekly wage calculations was, hey, we're not going to hit all of them, at the right mark, but we can get the majority of benefits to the injured workers appropriately. I've seen it multiple times where, yes, workers are making less in this situation, where other workers are making more on average weekly wage than calculations, time loss calculations, than they would have, had they been working. So I fully agree. I think average weekly wage needs to be taken a look at, but, yeah.
We'll look at DLC.
Yeah, there you go.
Other questions or thoughts from folks? You had your thinking face on, Kim. I want to give you an opportunity.
Well, I just, in my mind, yeah, Ryan clarified some things about the after tax and before tax. So, yeah, it's always under the assumption that the 66 2/3 was not taxed. So it did bring the injured worker to their, to their pay.
And I agree. I think that is the theory or the policy behind it. I think that the reason that they're bringing it, I know in my experience and the experience of other folks that have been through this, it doesn't, because the vast majority of people that I know, dozens and dozens and dozens who went through workers' comp claims in construction, it's not an equal replacement. It's not close. It's less, because predominantly the folks are making under the rate that you would expect that kind of level of taxation. Margaret and then Ryan, go ahead.
I appreciate the, I think it's, about even because it's 66 2/3%. And I think there are dozens and dozens and dozens of people who don't. I think what would be very useful for me is if you brought actual data. If someone is earning $12 an hour, if someone is earning $18 an hour, if someone is earning $40 an hour, and brought us those sort of calculations, it would make our analysis a little more meaningful.
And a kind of wrinkle in addition to that, I think if we have that overlay with what are the percentages of people making claims in those income brackets, if that makes sense. So you have sort of, this is what the outcome would be, and then maybe we see a huge disparate impact for low income workers. Maybe they're only 5% of claims, maybe they're 90% of claims. I think that tells a very different story as well.
I think
sorry.
No, you're okay. Go ahead.
I was just going to say what Margaret suggested would be helpful for me, because it would flip the switch for me, where I was always under the assumption that really highly compensated employees, it's hard for them to get to their rate of pay, and that's a motivator for them to get back to work. And then the opposite was when you have the lower compensated, because it's not taxed, then it brings their pay is about the same, and so it's harder to get them back to work. So that would be helpful for me to change my view.
That was my comment as well. Thank you, Coach Eric. Just, seeing some data on the tax bracket and how that would lay out would really be helpful. I think for the committee, we're I think hungry to look at average weekly wage. I think it's an identified problem, but what that looks like in the end will be interesting. You made a comment about time loss on accepted and compensable claims. And I just wanted to make a statement that, time loss is owed no matter whether it's compensable or deemed compensable. If it's still in deferred status, time loss is still owed. So, it doesn't need to be a compensable claim at that point. Time loss be being issued. Just wanted to add clarification.
Thank you.
We have someone online. I see Patrick's hand. Thank you, Patrick, for the patient.
Yeah, thank you very much. Can you hear me okay?
Yes.
Okay, good. I'm having a hard time hearing some of you in the room, but I think I made out most of it. I would like to say I really it's following up on, I raised my hand right before Margaret spoke. So I wanted examples as well. I think that would really help me when it comes back on an individual basis, but also on a system-wide basis. I'd like to know the burden on the system as well. And I imagine that's something you're planning to present, but I just wanted to lend my voice that'll be part of my thought process as well.
Thank you. That's a great point. Thank you, Patrick. And again, apologies for not seeing your hand earlier. You're very small in my peripheral.
Oh, no, it's okay. It's my fault for not being there. I wish I was there. It is better to participate in person for me. So thanks for accommodating my conflict today.
Other questions or thoughts from folks? I know we have a wonderful model of answering the MLAC questions from our friends at WCD, so would love one of those in addition to the LC when we get that.
Yes,
in the data.
you will get that. I think we've connected and have some time on the agenda in January to follow up and circle back and give some time to the drafter to get a draft back to me so I can compile all that for you.
Perfect. All right, thank you so much.
Thank you.
Okay, so we have up next will be our injured worker panel. I think we'll do a quick caucus beforehand. Let's say until 11:15.
Yeah, that works.
So that's a little more than 5 minutes.
Yeah. And Bob and Megan can take you to the breakout rooms. We have breakout rooms for you.
Perfect.
Okay.
How are we doing? I see Stacy. Taking that cheese stick off. Is Patrick still there? You know? That's probably
Do you see Patrick?
Oh, yeah. He's just not on camera.
Oh, okay. Perfect.
There he is.
Okay.
Okay, sorry that took a little longer than we had anticipated. Restarting here. Just wanted to recap a couple questions I know that remain outstanding on the WCD LCs. I know that Ryan, you'd requested a copy of the case to review, and I think we kind of agreed, had a few questions about that. So if we could get a copy of that, I think that would be helpful.
Okay.
And the data sheet that Matt was referencing, I think would be helpful in the analysis there. Regarding, so that's that was 390 or 394. 394.
Yeah.
The 390, I know that there were a couple questions that I had about the expansion of the exclusive remedy. And if we could see some stakeholder opinions on the use of the term co-employee and co-employment, I think I'd be curious. I know we heard the folks from NAPIO give their position on that and the importance to them, both nationally and sort of existentially. I don't want to say that because that's not exactly the right word, but on the use of those terms. So I think we will not be voting on those today. Margaret, I saw you had a question on that.
Well, I just wanted to ask also, and I apologize that my question is late, but I was wondering if certain specifically allocated that would, you anticipated that would be further defined by rule.
We'll get back to you on that.
Okay, thank you.
Yeah.
Okay. I'll make sure you got.
Thank you very much. Thank you. Appreciate your feedback, and we will get that back to you.
Thank you. So next up, we have injured worker panel. We have several different folks. It looks like in person today, we have Robert Anderson and
Capital Texas.
Austin.
Austin. Oh,
Gotcha,
sorry.
Robert Austin. My
Thank
apologies.
you. My apologies too.
And online virtually, we have Judy Britton. It looks like we had a third panelist who is not with us. I'll do one call online. Jesus Gonzalez Govea.
Hi, he is present. He's online. This is Apolinar Montero Sanchez. I'm one of the attorneys at the law firm that represents him.
Oh,
He's
perfect.
the one that says iPhone.
Oh.
Gotcha.
Oh,
Okay,
okay.
great. Glad I asked and put that out. So thank you much.
Yeah, is there an
So we-
interpreter there? I know that he'll need one.
Yes, we do have someone. Do you want to come up and maybe sit over here, and that way our friend the owl will be able to hear you. All right. So, do we have a structure for how folks want to kick off, or do you want to start perhaps?
Yeah, since I got to leave in a few minutes.
Sure.
I don't know if you have any questions, but basically my story is I got hurt a little over 4 years ago.
Do we have to ask you to speak up? Yes.
I got hurt about 4 years ago, November the 12th of 20. I've had subsequently 5 surgeries, 7 procedures. 1 more surgery scheduled. Don't know if there's anything past that. And to your guys' point of the 66 2/3 question, I've lost $114,000 since I've been injured off of my full wage. So it's not even remotely close to the regular wage. I don't know if you have any questions, but my issue is that they don't seem to pay on time, and when they don't, like the insurance company doesn't. I don't know if it's like a ploy to get you to like wave the white flag and surrender, because they do it a lot. So in the 4 years, 37 times they've not paid me like on time. And then subsequently, because of those non-payments, you have like derogatory payments, late payments, goes on your credit. So my credit score currently, before I got hurt, was 800. It's 390 right now because of their nonsense, right? Had to take a loan out on my truck that I own so that I could survive and not be dependent upon them not paying me on time. That sort of stuff, right? It's like ridiculousness. And I think they do it on purpose. At least it seems that way. Because all of a sudden, when you get the ombudsman's office to like put a fire under them, they pay you, but they don't pay you your late checks. Like the last time they didn't pay me, it was 5 consecutive weeks. I still haven't got the late checks for that, like the penalty check. And that was September. I just got the actual checks. And there's no additional penalty. Once it's a penalty, it's just a penalty, and it doesn't keep growing to put a fire under them to pay you on time. So once they're late, they don't care.
So to try and condense some of what you're saying, your perspective on your experience is that not only is the amount of money that you receive not enough, but it is also late. You then have additional costs relating to not having access to that money, and those costs are never reimbursed. So It's a kind of compounding effect on your financial well-being.
When you had a good credit score, you could borrow from the bank. But now that you're delinquent, you can't. So you go to predatory lending to get the money, right? Like, so it takes you, like those 4 checks, they owe me 25% of checks, so they owe me 1 check, so 5 checks. That 1 check's $1,200, but 16 payments is $1,500. I now ate another $300 because they were late. You know what I mean? And it didn't help repair my credit because it wasn't through the bank or any sort of reportable credit. You know what I mean?
Yeah. Any other kind of perspective, experience that you can share with us?
The fact that they took almost 3 years to do the first surgery when my arm wasn't able to move because of the injury. I separated my shoulder, tore my wrist and my elbow. It took them 34 months to do the first surgery. And you don't get pain and suffering, but you definitely have pain and suffering when you can't use either arm for 2 years. And then they finally do the surgery. And then they deny the bills. It comes back to you. Then your attorney gets them to pay it. But in the time that it was on your credit, another compounding, you didn't pay this $10,000 that you owe us. I don't owe it to you. It's workers' comp. But for 7 months, it was on my credit. And they don't have any repercussion. That's kind of my issue. Like, you've cost me $114,000 for being injured so far today.
And that amount of money that you're referencing, is that including the interest and fees and late payments amounts?
I
Or that's
my
just
truck,
the
right?
reduction?
Now I'm paying 5 more years on my truck because I took out the full amount. So now I'm paying 9 years of payments on a truck that it's going to cost me $85,000, was $35,000 new. And then I don't even know how much it's gonna cost me to actually go and find someone to repair my credit when it's all said and done. Right?
Any questions? I want to thank you for sharing. I know it's a harrowing experience, having been through it myself, and I haven't the words to wish you well that you deserve.
All right. I appreciate you guys listening.
Thank you so much for sharing your perspective. So I see next on the list we have Judy. And I do want to invite you. I know that you said, Robert, that you had to get going pretty soon here, but gotcha. Okay. Safe travels. Judy Britton, I believe is virtual.
Is she still on? Can you guys see if she's still online? Judy Britton. She was online just when we were on break. She's not online. Okay.
All right, we can maybe attempt to reach out to her. I see that we do have another, the panelist, Jesus, and we have an interpreter, it's my understanding.
Jesús, ¿está en la línea? ¿Me escucha?
He's on mute.
Jesús, parece que tiene el sonido apagado.
A ver, ¿me escucha?
Sí, ya lo escuchamos.
¿Sí? Ok.
Jesús, ¿nos quiere platicar de su experiencia que tuvo?
Sí, el día 20 de septiembre de 2024, o sea, de este año, tuve un accidente de trabajo.
Okay, so this year, in November, he had a work injury. Jesús dijo el año pasado?
No, este año, 2024.
Este año, okay, this year. Okay, he had a work injury. ¿Y qué más?
Yo trabajaba en el roofing y me caí.
Sorry. Sí, diga.
Y me caí de un tercer piso.
He was working as a roofer and he fell off a third floor.
Y de ahí, de partir del accidente, mi vida ha cambiado mucho y me ha afectado bastante en mi familia.
And since that accident, it has affected his personal life, his family.
Pues también me ha afectado, psicológicamente y emocionalmente y al grado de que no hemos tenido ningún dinero.
So he's saying it's affected him emotionally, psychologically, and financially because there hasn't been any money coming in.
Ya que yo era el proveedor de la familia, el único que trabajaba aquí en casa.
Because he is the breadwinner and he isn't able to support his family.
Mi esposa era la que me cuidaba y ahora tuvo que pedir un part-time para poder sobresalir un poco para poder comer.
Yeah, his wife is the one that's been taking care of him, but because of the financial hardship, she had to get a part-time.
Ya que yo pues todavía estoy lesionado, ella es la que pues me ayudaba a bañarme y ciertas cosas, pues me ayudaba aquí en la casa, ya que yo no puedo cargar cosas pesadas.
She's been having to help him with his like day-to-day, bathe him, just the everyday day-to-day things because he's not able to.
Tengo 5 hijos y mi empleador no se quiso hacer cargo de nada, no tenía el seguranza.
He said he has 5 kids. His employer did not have workers' comp.
Tuve que, al no recibir yo nada ni ayuda, tuve que solicitar una abogada.
So he didn't have any help. He did reach out to an attorney.
Ahora no sé qué va a pasar conmigo después del accidente. No sé que si mi vida va a ser de nuevo otra vez igual porque tengo todavía graves lastimaduras.
He's uncertain of what the future holds or what he's going to be able to do because he's still injured.
En el accidente me quebré 9 costillas y me quebré un hueso del cuello y mi pulmón tuvo que ser tuvieron que drenármelo con un tubo.
He broke up 9 ribs, hurt his back, and his lung due to the injury.
Y todavía tengo una trauma cada vez que salgo, veo los techos y por causa de eso.
He's saying he's also traumatized when he goes out and sees, looks at roofs because of what happened to him.
En este momento me siento muy preocupado y estresado y no sé qué porque va a pasar conmigo, pero estamos tratando de hacer todo lo posible porque esta persona se haga responsable y ya que pues ahorita aquí en mi hogar estamos muy económicamente muy mal.
He's worried, but he's hoping that something will get resolved because they're struggling financially.
Estamos pidiendo nosotros ayuda en la iglesia donde yo asisto y es lo único que me ha ayudado un poco. Pues lo único que puedo decir es de que no sé si mi vida volverá a ser de nuevo otra vez y voy a poder yo trabajar a futuro.
He's saying he did reach out to his church, and they have been helping him, but he's uncertain of what the future holds. If he's ever gonna go back to how it was before.
Ya que yo soy el que pues me hago cargo de mis 5 hijos, la mayoría, ya que pues yo era el que podía proveer más dinero que yo que trabajaba en la construcción anteriormente.
And he has 5 kids, so it's a tough situation, and he's just unsure of what's going to happen. But hopefully, something will get resolved.
Y hasta ahorita pues la persona esta pues no recibió ningún dinero de ninguna parte, he recibido dinero hasta ahorita.
And till this point, he still has not received any benefits, any money coming in.
Do you have any questions from folks? I see Barb.
I'm just curious if he's been able to, has he had treatment?
Jesús, alguien preguntó si usted ha tenido ese tratamiento médico, ha podido ir al médico.
Solamente fui nomás una vez que me checaron el cuello porque dijeron como estaba averiguando de que esta persona no tiene aseguranza, tenía que tener un número de reclamo y hasta apenas hace 1 o 2 días que lo tuve y apenas voy a poder que me van a poder checar ahora.
So yes, initially he was able to have his neck checked out, but because he didn't have a claim number, he wasn't able to get more medical treatment. He just got it, I think Jesús, ¿cuándo se lo dieron su número de reclamo?
Apenas hace como, creo que, ¿sí fue 2 días? Hace como 2 días, más o menos.
2 days ago, he just
Y
got
estuve en el hospital por 4 días en el hospital.
He
Cuando
was
fue
in
el
the-
siguiente.
Okay, and he was originally in the hospital for 4 days when he got injured. But that's about it.
Ryan?
Yeah, thank you, Co-Chair. Can you tell us what the date of injury was for him? if he's willing to
Jesús,
share?
¿cuándo fue su día de accidente? ¿La fecha del accidente?
Estuve del 20 al 24 de septiembre.
¿Pero cuándo se accidentó? La fecha.
2024, fue septiembre.
¿Septiembre de qué día, perdón?
Del 20, estuve del 20 al 24.
Okay, September 20th of 2024. And he was in the hospital for those four days.
Thank you.
Yeah, if I could chime in on his behalf really quick. In this situation, the employer did not have workers' comp insurance, as he mentioned, and also denied that Jesus worked for them. So there's like a 90-day process where they're investigating if there is insurance, and during that entire time, an injured worker is not getting paid. So that's why he's not received any wage loss. And that's not something that's uncommon, you know.
También quería agregar algo que pues hasta ahorita estoy bien, bien preocupado porque pues tenía un carro yo de la aseguranza, tenía pues tengo la renta, no la he pagado. Pues en la casa me hace falta comida, me hace falta muchas cosas que cuando yo trabajaba yo aportaba todo eso y ahora ya no, ahora que estoy accidentada ya no las puedo aportar.
He additionally just wanted to comment and add that he hasn't been able to pay rent, car payments, bills that he hasn't been able to pay for this.
Same question.
Yes, sir.
Jesus, but how does the system work in that case? Does the employer get penalized? I mean, hopefully, like, where do we go to like deal with this bad actor?
Do you want to translate the question that was asked?
Jesús, alguien hizo una pregunta, no para usted, pero él hizo un comentario, ¿no? De que qué pasa con el empleador, ¿quién los van a penalizar? Preguntaron, quieren saber más sobre el sistema de qué le pasa al empleador por no haber tenido cobertura.
Pues lo único que sé es que me llegó un papel diciendo de que ya lo había encontrado a él, culpable. Y supuestamente en el papel dice que esa persona tiene 60 días para apelar como nada más.
Yeah, he just commented that he just finally received the notice that the employer is non-complying, but it does, he just made another comment that the employer can appeal, and why?
Go ahead. Sure. Hi, Matt again, Interim Administrator, Workers' Compensation Division. So the current statute, so if an employer does not have workers' compensation coverage, the claim comes to our division, to WCD, and we have an employer compliance unit, and they have current law statute gives the division 60 days to investigate the claim. And during that investigation, we're looking to see if there was coverage. Oftentimes the claim comes to us and we're able to find coverage. That's the best case scenario. In cases where we don't find coverage, it's assigned to an investigator, and they're looking at the subjectivity of both the employer and the worker, ensuring that that the worker is a subject worker and that the employer was their employer, not an independent contractor type relationship. And then once that investigation's complete, if we find that the employer was non-compliant, should have had coverage, everything checks out, then we refer that to a claims processor that we have a contract with to process these claims. So then they once it's referred there, claim number's assigned, and it's then processed like any other claim. The employer is issued a civil penalty amount determined. There's a formula to determine how much the penalty would be, and then the employer is also responsible for all the claims costs. They're paid initially. We reimburse the claims processor out of the workers' benefit fund, and then we go after the employer for the penalty and claims costs ongoing. So as long as there are claims costs, that employer, their obligation to pay those claims costs back remain.
And go ahead, Brian.
So you're saying they get 60 days to review for coverage. If it's identified that, hey, this is a non-compliant, gets referred to an investigator, the claim process starts. Does that mean there's another whole 60 days for the compensability investigation to go forth at that point? So we're possibly looking at 120 days before they're decided if their claim's accepted or denied.
Correct. Yes. And the obligations start at that point. So if time loss is owed, it would be when we refer it, the claims processor has 14 days to send the worker time loss if it's authorized and they're unable to work. They start the claim process at that point.
Would that payment backdate to date of injury. Let's say they had authorizations from date of injury up until, yep, this is a actual claim. We're going to submit it with the insurer. Does that make sense?
Yeah, so
Do
we
they then
recently,
cover that?
yeah, and that was a question that came up, and we recently looked, and the cases that we looked at the claims processor is, so let's say that it took 60 days to do the investigation, another 14, they have been paying that entire amount owed with the first time loss check, and then they're every 14 days.
But I could see a situation like here where he doesn't have a claim number, so the providers are unwilling to see him, so he's not able to get that authorization. I could see this snowball effect, right, over the 120 days.
It is, yeah, and it's, just, our investigators prioritize, these and try to resolve the investigation as quickly as possible, even though the statute gives 60 days, we're not, we're trying to get them resolved and get the investigation completed sooner so that we can get the claim referred if it is a claim.
Interesting. Thank you. I appreciate that.
And I guess a couple questions that I had in what you mentioned. One, the civil penalty that is assessed on the employer, where does that go to the worker, or does that go into the worker benefit fund, or
that goes into the worker benefit fund?
And the worker benefit fund, does that have provisions to pay workers or only to pay the claim processor for processing them?
So we pay the claim processor what their fee is to process the claim, and then we reimburse the claim processor for time loss payments to the worker, medical bills. So everything that the processor is paying the worker or physicians, the worker benefit fund reimburses the claims processor, and then those claims costs get added to the amount of money that we're attempting to recover from the non-complying employer.
And does that amount of money include any penalties or interest or fees that the worker has had out of pocket for that potentially 120 days?
No, it's strictly claims costs and then the contracted fee to process the claim.
And the injured worker has no direct access to the worker benefit fund during that time. Is that correct?
That's correct.
Margaret?
And has the department, you see this happening, has the department ever considered doing something, creating interim benefits for the workers similar to during the compensability investigation?
It's been discussed.
I figured it has.
Yes, I believe there'll be more discussion at MLAC moving forward. Current statute doesn't allow that, so that it would be a statutory change. And the statutory change would be needed for that to happen.
Right.
And I saw Sarah and then Lauren.
Do you do any proactive audits for the employers in the state to ensure coverage is there to prevent this type of issue?
Yes, our number one goal is compliance. We want to make sure that that employers have coverage so that workers are protected. These situations are ones that we do everything we can to avoid. We do a lot of outreach, education. We have a team of investigators. I mentioned our employer compliance unit. When, for example, if an insurer cancels coverage with an employer, we get notice of that, and then our investigators start proactively reaching out to those employers saying, hey, it looks like your coverage was canceled. Do you have new coverage? So we're trying everything we can with whatever information we have to proactively reach out to employers to ensure that they have the coverage in place. Unfortunately, there's not a list of non-compliant employers.
No,
but yeah, our
but
team
obviously being on the proactive side is better than
absolutely
being here.
Yeah, and our team, is constantly looking for new ways to educate employers of their obligation to have coverage in situations where there is a non-complying employer order issued. We monitor, and after a certain amount of time they haven't secured coverage, we'll do a reinvestigation and can issue additional penalties if they haven't secured coverage.
And I know this may take a statutory change, but it's my understanding that California interfaces between the California equivalent of what is the CCB and the list of licensed construction contractors, because I know that this is especially a problem in the construction industry. And it's sort of that web that you touch, I know the carpenters and some others have done some investigations and work into this of cash business in construction, misclassification and misidentification of workers as independent contractors, and there's sort of this huge laundry list of problems that goes with the creation of that underground economy. But I know since CCB and WCD are at least housed under the same agency, if there's any way to kind of interface those or pull periodically a list of all licensed contractors.
Yeah,
that is just a recommendation of mine. And if there's any statutory fixes that would be needed to facilitate that, I would more than happily be a part of that process.
No, I appreciate that. And there is a, I think it's ICN, Interagency Compliance Network, I believe is what it's called. But our WCD partners with CCB, Department of Revenue, and we will go out with representatives from those agencies and do what we call sweeps. So they'll show up to construction sites. CCB is looking for licensing. We're looking for coverage. So we do participate in something similar with other agencies to, again, proactively try to make sure that those they're not incorrectly saying they're independent contractors, that they have the obligation for coverage, educating and following up and issuing penalties if necessary.
And I know that there's more work that the trades need to do. We do a lot of prevailing wage enforcement and facilitating prevailing wage enforcement for agencies. I think we should do a better job connecting with you when we find cash-only businesses that are improperly classifying people for prevailing wage purposes. Likely there's also all of these other issues that we find on site. So if there's a way that we can connect with your enforcement department, that would be helpful.
Yeah.
Sort of, independent of that.
Yeah, I appreciate that. We accept, tips, if you will. Hey, you should go look at this employer. Our team takes those and we take those seriously and we investigate.
Lauren, you've been very patient.
Scott largely beat me to my question and put it a lot more eloquently than I would have. I think my main question was, and I'm unsure, so if someone has a willful violation of workers' comp or is not paying into that, is there a mechanism to then go to CCB and say this person or this business is ineligible to have a contracting license?
That's a good question. I'll look into that. I don't know what communication we share with CCB posts like we found employers non-complying. I'm not sure. We do, but I'll check with our program area and we'll follow up.
Thank you.
It's my understanding that, and it's been a while since I've looked into this, that the CCB statutes do provide for kind of behavior that's deleterious to the public interest or something as a licensing problem potentially. But I know that it has been a while since agencies have forwarded complaints, be it prevailing wage or OSHA or other issues, especially obviously willful issues like this. So I would agree that there could be better support for that. And I think do I see it?
Yes.
Yeah, please.
Hi, my name is Josh McNeil with Corvell Corporation. You're a claims administrator, and in my professional and personal experience, I wanted to speak to this issue with the CCB. But I have, and I don't know how the communication happens, but I have experienced multiple contractors who have found non-complying employers, their CCB license were suspended until they could prove that. So I'm not sure the mechanism by which that happened. I only can say that it has happened.
Right. The 60-day investigation period to determine, if they're non-compliant, if they're an employee, all that kind of stuff. On average, you probably can't speak to this right now. I'd be curious to see on average how long those investigations take. If that 60-day window can be tightened up a little bit, seems like a long time. Though I know investigating compensability in 60 days can be hard sometimes as well. So just kind of curious to see maybe some more data on how long those investigations typically take if it's available.
We can certainly provide that. I don't know the numbers off the
Yeah,
top of my head.
yeah.
We can certainly provide that information.
Yeah, excellent.
Any other questions? If he has any other comments that he would like us to know in particular, or a final parting word, I would appreciate that.
Jesús, ¿quieren saber si tiene como un último comentario o algo que quiera usted decirles para terminar?
Pues solamente que quería comentar algo, que ya había comentado un poco. Lo único que puedo decir es de que, pues, a través de esto lo que me pasó el accidente, que por poco muero, si hubiera dado un poco más, si hubiera dado un poco más que no me hubieran llevado al hospital por parte de mi pulmón que estaba ya colapsando. Lo único que puedo decir es de que, mi mensaje, les pido de favor que lo tomen en consideración y pues espero que para que cuando otras personas que pasaron por lo mismo que yo, los puedan ayudar.
He just wants to let everyone know that it's a hard process, but he almost lost his life because his lung almost collapsed. But he wants everyone to know that if you can just take it into consideration, that help these individuals, help with the system to get assistance for workers' comp during the NCE process.
Does he know if the employer is still actively performing construction work elsewhere?
¿Sabe si el empleador sigue contratando, sigue en su negocio o dejó de parar?
Sé que tiene su compañía todavía porque por base de, no por mí, sino porque lo han investigado a él. Nada más.
Yeah, he's still doing business. Dice que muchas gracias por su testimonio. Muchas gracias.
Ok. ¿Y cree que puedo colgar?
Sí, ya.
Ok. Muchas gracias.
Muchas gracias.
All right. Any other questions or comments from folks, including anybody online? I will take just a second. I know that we recently went through mental health training, and I do want to identify to everybody that the holidays can be a very stressful time for a lot of folks. So please do reach out. As we've seen some mention made from some individuals that are in our community, both they and their families are undergoing extremely stressful, difficult times. So do be there for each other, reach out for each other. Make a point of being helpful and available if possible. A lot of folks are going through a very hard time, and even those, you would be surprised by those who are as well. So do want to say that and make a point to hold some time for that and folks to think about that. Upcoming meetings, I see we have a January 9th, 2025 in person and a January 23rd, 2025 virtual, and have some notes for WCD and other folks to bring back, and we'll be expecting, I believe, from AFSCME and hopefully an update on their LC. I do want to thank everyone for their time and participation and for their patience in running over a few minutes. Thank you. Yep.